material during the last round. Is there an exception in the law for current or former U.S. officials who request anonymity?
To release classified information?
Yes, sir.
No.
Is there an exception in the law for reporters who want to break a story?
Well, that's a harder question as to whether a reporter incurs criminal liability by publishing classified information, and one probably beyond my ken. I'm not as good a lawyer as Mr. Schiff said I used to be.
Well, I don't know about that, but the statute does use the word publish, doesn't it?
It does, but that's a question I know the Department of Justice has struggled with through administration after administration.
I know the Department struggled with it, the Fourth Circuit struggled with it, lots of people have struggled with it, but you're not aware of an exception in the current dissemination of classified information statute that carves out an exception for reporters.
No, I'm not aware of anything carved out in the statute. I don't think a reporter has been prosecuted, certainly in my lifetime, though.
Well, there have been a lot of statutes that bar in this investigation for which no one's ever been prosecuted or convicted, and that does not keep people from discussing those statutes, namely the Logan Act. In theory, how would reporters know a U.S. citizen made a telephone call to an agent of foreign power?
How would they know legally?
Yes.
If it was declassified and then discussed in a judicial proceeding or a congressional hearing, something like that.
And assume none of those facts are at play, how would they know?
Someone told them who shouldn't have told them.
How would a reporter know about the existence of intercepted phone calls?
Well, same thing. In a legitimate way, through an appropriate proceeding where there's been declassification. In any other way, in an illegitimate way.
How would reporters know if a transcript existed of an intercepted communication?
Same answer. The only legitimate way would be through a proceeding, appropriate proceeding. The illegitimate way would be somebody told them who shouldn't have told them.
What does the term mask mean in the concept of FISA and other surveillance programs?
As Director Rogers explained, it's our practice, approved by the FISA court, of removing the names of U.S. persons to protect their privacy and their identity unless it hits certain exceptions. So masking means, as Mike Rogers said, I'll often see an intelligence report from NSA that will say U.S. person number 1, U.S. person number 2, U.S. person number 3, and there's no further identification on the document.
Admiral Rogers said there are 20 people within the NSA that are part of the unmasking process. How many people within the FBI are part of the unmasking process?
I don't know for sure as I sit here. Surely more, given the nature of the FBI's work. We come into contact with U.S. persons a whole lot more than the NSA does, because we may be conducting, we only conduct our operations in the United States to collect electronic surveillance, to conduct electronic surveillance. So I can find out the exact number. I don't know it as I sit here.
Well, I think, Director Comey, given the fact that you and I agree this is critical, vital, indispensable, a similar program is coming up for reauthorization this fall with a pretty strong headwind right now, it would be nice to know the universe of people who have the power to unmask a U.S. citizen's name, because that might provide something of a roadmap to investigate who might have actually disseminated a masked U.S. citizen's name.
Sure, the number is relevant, but what I hope the American people will realize is the number is important, but the culture behind it is, in fact, more important. The training, the rigor, the discipline. We are obsessive about FISA and the FBI for reasons I hope make sense to this committee, but everything that's FISA has to be labeled in such a way to warn people, this is FISA. We treat this in a special way. So we can get you the number, but I want to assure you the culture of the FBI and the NSA around how we treat U.S. person information is obsessive, and I mean that in a good way.
Director Comey, I am not arguing with you, and I do agree the culture is important. But if there are 100 people who have the ability to unmask and the knowledge of a previously masked name, and that's 100 different potential sources of investigation. And the smaller the number is, the easier your investigation is. So the number is relevant. I concede the culture is relevant. NSA, FBI, what other U.S. government agencies have the authority to unmask a U.S. citizen's name?
Well, I think all agencies that collect information pursuant to FISA have what are called standard minimization procedures, which are approved by the FISA court that govern how they will treat U.S. person information. So I know the NSA does, I know the CIA does, obviously the FBI does. I don't know for sure beyond that.
How about the Department of how about Maine Justice?
I mean, Maine Justice, I think, does have standard minimization procedures.
All right, so that's 4. The NSA, FBI, CIA, Maine Justice. Does the White House have the authority to unmask a U.S. citizen's name?
I think other elements of the government that are consumers of our products can ask the collectors to unmask. The unmasking resides with those who collected the information. And so if Mike Rogers' folks collected something and they send it to me in a report and it says U.S. person number 1 and it's important for the FBI to know who that is, our request will go back to them. The White House can make similar requests of the FBI or of NSA, but they can't they don't on their own collect, and so they can't on their own unmask. I got that about right?
Yeah, that's correct.
I guess what I'm getting at, Director Comey, is you say it's vital, you say it's critical, you say it's indispensable. We both know it's a threat to the reauthorization of 702 later on this fall. And, oh, by the way, it's also a felony punishable by up to 10 years. So how would you begin your investigation, assuming for the sake of argument that a U.S. citizen's name appeared in the Washington Post and the New York Times unlawfully? Where would you begin that investigation?
Well, I'm not going to talk about any particular investigation.
That's why I said in theory.
You would still figure out, so who are the suspects? Who touched the information that you've concluded ended up unlawfully in the newspaper, and start with that universe, and then use investigative tools and techniques to see if you can eliminate people or include people as more serious suspects.
Do you know whether Director Clapper knew the name of the U.S. citizen that appeared in the New York Times and Washington Post?
I can't say in this forum because, again, I don't want to confirm that there was classified information in the newspaper.
Would he have access to an unmasked name?
In some circumstances, sure. He was the Director of National Intelligence, but I'm not talking about the particular.
Would Director Brennan have access to an unmasked U.S. citizen's name?
In some circumstances, yes.
Would National Security Advisor Susan Rice have access to an unmasked U.S. citizen's name?
I think yes, in general, and any other national security advisor would, I think, as a matter of their ordinary course of their business.
Would former White House advisor Ben Rhodes have access to an unmasked U.S. citizen's name?
I don't know the answer to that.
Would former Attorney General Loretta Lynch have access to an unmasked U.S. citizen's name?
In general, yes, as would any Attorney General.
So that would also include acting AG Sally Yates?
Same answer.
Did you brief President Obama on, well, I'll just ask you, did you brief President Obama on any calls involving Michael Flynn?
I'm not going to get into either that particular case, that matter, or any conversations I had with the President, so I can't answer that.
Well, Director Comey, there's been some speculation this morning on motive. I'm not all that interested in motive. First of all, it's really hard to prove. Secondarily, you never have to prove it. But I get that people want to know. The jury always wants to know why. I think you and I can agree there are a couple of reasons that you would not have to unlawfully, feloniously disseminate classified material. It certainly wasn't done to help an ongoing criminal investigation because you already had the information, didn't you?
Again, I can't answer in the context of this particular matter.
How about in theory? Is there something a reporter would have access to that the head of the FBI would not?
It's hard for me to answer. I would hope not when it relates to the
I would
FBI.
hope not, too, since it's part of our surveillance programs. I would hope that you had access to everything as the head of the world's premier law enforcement agency. I would hope that you had it all. So if you had it all, the motive couldn't have been to help you because you already had it. And Admiral Rogers, the motive couldn't have been to help you because you already had it. So in the universe of possible motives for the felonious dissemination of classified material, we could rule out wanting to help the intelligence communities and the law enforcement communities. Those are two motives that are gone now. That leaves some more nefarious motives. Is the investigation into the leak of classified information, has it begun yet?
I can't say because I don't want to confirm that that was classified information.
Well, I don't want to quarrel with you, Director Comey, and I do understand that you cannot ordinarily confirm or deny the existence of an investigation. But you did it this morning citing DOJ policy given the gravity of the fact pattern. Would you not agree that surveillance programs that are critical, indispensable, vital to our national security, some of which are up for reauthorization this fall, that save American lives and prevent terrorist attacks, also rises to the level of importance?
I think those programs are vital, and leaks of information collected pursuant to court order under those programs are terrible, and as I said in my opening statement, should be taken very, very seriously. What I don't ever want to do is compound what bad people have done and confirm something that's in the newspaper, because sometimes the newspaper gets it right. There's a whole lot of wrong information allegedly about classified activities that's in the newspaper. We don't call them and correct them either. That's another big challenge, but we just don't go anywhere near it because we don't want to help and compound the offense that was committed.
I understand that, Director Comey, and I'm trying really hard not to get you to discuss the facts at bar. But some of the words that appeared in this public reporting include the word transcript, which has a very unique use in the matters that you and I are discussing this morning. That is a very unique use of that word. Wiretap has a very specific meaning. The name of a U.S. citizen that was supposed to statutorily be protected is no longer protected. So some of this reporting, let's assume 90% of it is inaccurate. That other 10% is still really, really important. And to the extent that you can rely on the dates in either the Washington Post or the New York Times, we are talking about February of this year is when the reporting first took place. So we're a month and a half or 2 months into something that you and I agree is incredibly important and also happens to be a felony. So I'm just simply asking you to assure the American people, you've already assured them you take it really seriously. Can you assure them that it is going to be investigated?
I can't, but I hope people watching know how seriously we take leaks of classified information, but I don't want to confirm it by saying that we're investigating it. And I'm sorry I have to draw that line. I just think that's the right way to be.
Well, I'm not going to argue with you, Director Comey, but it is, we're going to discuss a lot of important things today. Whether Russia attempted to influence our democratic process is incredibly important. Whether they sought to influence it is a separate analysis, incredibly important. The motive behind that interference and influence, incredibly important. Our U.S. response, incredibly important. Some of that may rise to the level of a crime. Some of it does not rise to the level of a crime. One thing you and I agree on is the felonious dissemination of classified material most definitely is a crime. So I would ask you, and I understand some of the procedures that you are up against, I would humbly ask you to seek authority from whomever you need to seek authority from. Because I'm going to finish the same way I started. This is an agreement between the American people and its government. We, the American people, give certain powers to government to keep us safe. And when those powers are misused, and the motive is not criminal investigations or national security, then I'll bet you my fellow citizens are rethinking their side of the equation. Because that U.S. citizen could be them next time. It could be you. It could be me. It could be anyone, until we start seriously investigating and prosecuting what Congress thought was serious enough to attach a 10-year felony to. With that, I would yield back, Mr. Chairman.
Can I just add a response to what you said? I agree with you, Mr. Gowdy. Two things folks at home should know. First, an unauthorized disclosure of FISA is an extraordinarily unusual event, so be assured we're going to take it very seriously because our trust with the American people and the federal judges that oversee our work is vital. And second, that this conversation has nothing to do with 702. Folks often mix them together. 702 is about targeting non-U.S. persons overseas. Pursuant to the FISA statute, the FBI can apply to collect electronic surveillance in the United States, but it's a different thing from 702. The conversation you and I are just having is about this, which is vital and important, but I just didn't want to leave folks confused.
Director Comey, you are 100% correct. And I am 100% correct in saying that that is a distinction that doesn't make a difference to most of the people watching television. You are exactly correct. What we are reauthorizing this fall has nothing to do with what we are discussing, other than it is another government program where the people consent to allow government to pursue certain things with the explicit promise it will be protected. So you're right, they're different. But in the eyes of people watching, it is the U.S. government officials leaking the name of a U.S. citizen, and if it can happen here, it may happen there. Trust me, you and I both want to see it reauthorized. It is in jeopardy if we don't get this resolved.
We are scheduled to have Mr. Pagliano attend this hearing. Due to his absence and his violation of a duly issued subpoena by the Committee on Oversight and Government Reform, we intend to adjourn this hearing and immediately convene a business meeting to reconsider a resolution and report holding Mr. Pagliano in contempt of Congress. Does Mr. Cummings, do you have a statement, or can we go ahead and adjourn?
I have a brief statement.
Sure.
Well, let me just say this. This is certainly no surprise to anyone. Mr. Pagliano's attorney told us last week he wouldn't be here. They told us it would be an abuse to force him to appear for a second time before Congress just to assert his Fifth Amendment rights. And they sent us another letter last night saying exactly the same thing. Let me read from one portion of the letter so there's no question about what is going on here. And I quote, "We have corresponded extensively with you and the committee's attorneys over the past 2 weeks on this subject. The facts have not changed." Continuing the quote, "You and the committee have been told from the beginning that Mr. Pagliano will continue to assert his Fifth Amendment rights and will decline to answer any questions put to him by your committee," end of quote. The letter explains that he already asserted his Fifth Amendment rights before the Benghazi Select Committee, and he should not be forced to do so a second time. The letter continues, and I quote, "A subpoena issued by a congressional committee is required by law to serve a valid legislative purpose, and there is none here. You demand, under the present circumstances, that Mr. Pagliano again assert his constitutional rights in front of video cameras 6 weeks before the presidential election, portrays a naked political agenda and furthers no valid legislative aim," end of quote. I ask unanimous consent that this full letter from Mr. Pagliano's attorney sent last night to the committee be entered into the official record. I have nothing else on that, Mr. Chairman.
Without objection, so ordered. The hearing is adjourned. Committee on Oversight and Government Reform will now come to order. Pursuant to Committee Rule 5B and House Rule 11-2H4, the committee announces that it may postpone further proceedings today on any question of approving any measure or matter or adopting an amendment on which a recorded vote of the yeas and nays are ordered, and without objection, the chair is authorized to declare a recess at any time. This is a full committee business meeting to consider the resolution and report recommending to the House of Representatives to find Brian Pagliano in contempt of Congress for refusal to comply with a subpoena duly issued by the Committee on Oversight and Government Reform. Our first and only item for consideration today is a resolution and report recommending that the House of Representatives find Brian Pagliano in contempt of Congress for refusal to comply with a subpoena duly issued by the Committee on Oversight and Government Reform. The clerk will designate the report.
Resolution recommending that the House of Representatives find Brian Pagliano in contempt of Congress for refusal to comply with a subpoena duly issued by the Committee on Oversight and Government Reform.
I intend to offer an amendment in the nature of a substitute to the report, and without objection, we will call up the amendment in the nature of a substitute, and then I will recognize myself to give one statement on both the ANS and the underlying report. The clerk will designate the amendment.
Amendment in the nature of a substitute offered by Mr. Chaffetz of Utah to the resolution recommending that the House of Representatives find Brian Pagliano in contempt of Congress.
Without objection, the amendment is considered as read, and I now recognize myself for 5 minutes in a statement to report on the report and the ANS. Today, the committee will consider a resolution and report recommending Brian Pagliano be held in contempt of the House of Representatives. Subpoenas are not optional. Mr. Pagliano is a crucial fact witness in this committee's investigation of former Secretary of State Hillary Clinton's use of a private email server to conduct government business. The release of these federal records is of deep concern to the committee, and we have the jurisdiction over federal records. We have jurisdiction over National Archives. We have jurisdiction in several places. Over the course of the investigation, we learned some of the information about Mr. Pagliano's involvement in Secretary Clinton's use of the private server. Mr. Pagliano originally worked for Secretary Clinton in her 2008 presidential campaign as an IT specialist. As he was closing out her campaign's computer equipment, he received a call from Justin Cooper, who testified before this committee last week. It was Mr. Cooper who requested Mr. Pagliano build a server for Ms. Clinton in early 2009 as she started her new job as Secretary of State. Several months later, in March of 2009, the two men met in the basement of Clinton's Chappaqua residence to install a new server Mr. Pagliano built. Mr. Pagliano continued to monitor and maintain the server while Secretary Clinton was at the State Department. After he set up the server, Mr. Pagliano joined Secretary Clinton at the State Department as a Schedule C appointee in the Bureau of Information and Resource Management. By law, Schedule C appointees are required to report to a presidentially appointed position, but there were no presidential appointees in the Bureau of Information and Resource Management, making Mr. Pagliano's employment arrangement unusual at best. Other employees in his bureau later questioned his ability to support a private client's email server, given his capacity as a full-time government employee. Mr. Pagliano left the State Department in February of 2013, the same month as Secretary Clinton. Even though he worked at the State Department for almost 4 years, the agency has been only able to find a handful of emails. We have questions about this. Mr. Pagliano's emails are federal records, just like Secretary Clinton's emails, and subject to production in response to a Freedom of Information Act request. The committee has jurisdiction of both the Federal Records Act and FOIA. We also have a long record of oversight, investigative, and legislative work in this area. The committee subpoenaed Mr. Pagliano to appear at a hearing on September 13, 2016. He did not show up to that hearing. I explained Mr. Pagliano was uniquely qualified to provide testimony to help the committee better understand Secretary Clinton's use of a private email server. This is undisputable. I also made clear the committee would consider all options regarding Mr. Pagliano's failure to appear, including consideration of recommending he be held in contempt. The committee then heard several hours of testimony from Mr. Cooper, who was also involved in setting up Secretary Clinton's email server. Mr. Cooper, to his credit, explained a lot. We did appreciate his participation in answering all the questions that this committee asked. Throughout his testimony, Mr. Cooper routinely referred to Mr. Pagliano as the individual more appropriate to answer questions who knew more about the server. It was clear from Mr. Cooper's testimony, his words, not ours, that we needed to hear from Mr. Pagliano. Mr. Pagliano's attorney asserts because his client took the fifth before the Select Committee on Benghazi, he shouldn't be required to provide testimony to this committee. That is not a good faith argument. It makes no sense for a number of reasons. First and foremost, the Select Committee's jurisdiction is limited. It only relates to September 11, 2012 terrorist attack in Benghazi. In contrast, this committee's jurisdiction is broad and includes both legislative and oversight of the Federal Records Act and the Freedom of Information Act. Questions about these two topics alone are well outside the purview of the Select Committee's investigation. Secretary Clinton's emails and Mr. Pagliano's were subject to both of these laws. Mr. Pagliano could explain what he knew or what he was told about these laws. He could tell us whether or not they were considered by him or others in setting up Secretary Clinton's private email server. Mr. Pagliano's testimony could provide important information, informing legislative reforms that this committee may want to consider, ensuring that this disaster never happens again. This includes reforms based on how he was able to prevent the State Department from locating most of his emails. Another key difference in last month, this committee had the benefit of reviewing the testimony Mr. Pagliano did provide during his interview with the FBI. The Select Committee never did see that, 302. Nor was the Select Committee aware of the thousands of classified emails that traveled over Secretary Clinton's server when they spoke with Mr. Pagliano. This committee's questions are broader and more informed than any questions posed by the Select Committee, making a comparison unnecessary. Further, answering a number of these questions could never subject Mr. Pagliano to criminal liability. The Department of Justice has confirmed Mr. Pagliano was granted immunity before he spoke to the FBI. Director Comey confirmed that he was recommending no charges be brought against anyone involved in the matter. Attorney General Lynch accepted the recommendation and closed the case. Under those circumstances, Mr. Pagliano has no fear of criminal liability preventing him from answering questions before this committee. The committee recessed its September 13th hearing with Mr. Cooper to give Mr. Pagliano another opportunity to show up and testify. To clear up any ambiguity created by Mr. Pagliano's 6 lawyers about whether they would confirm service of the prior subpoenas, which they refused to do, we had the U.S. Marshals personally serve him. We scheduled the continuation of the earlier hearing for this morning, but once again, he failed to show. This committee cannot operate. It cannot perform its duty, nor can any committee of Congress if subpoenas are ignored. So we are left with no choice but to consider this resolution, a report recommending the House hold Mr. Pagliano in contempt of Congress. Now, recognize the ranking member, Mr. Cummings.
Thank you very much, Mr. Chairman. Yesterday, our committee held a very important hearing on a very critical issue that matters to millions of the American people, the skyrocketing prices of prescription drugs. Members on both sides of the aisle joined together to examine these abuses in a truly bipartisan way. That is exactly the kind of investigation our committee should be conducting, and that is the kind of investigation that the American people would want us to conduct. But today's spectacle is just the opposite. This is nothing but a blatantly partisan Republican attack on the Democratic candidate for President of the United States of America. It undermines the integrity of our committee, and it makes our constituents disgusted with Congress instead of proud of our work. Today is our 5th day of, quote, emergency, end of quote, hearings on Hillary Clinton's emails in the past 3 weeks. 5th day of emergency hearings on Hillary Clinton's emails in the past 3 weeks. In that period, the chairman has issued an astonishing 12 subpoenas. If you don't count weekends, that's more than 1 a day. It's also more than 1/3 of the total number of subpoenas he issued in all of 2016. Got an emergency here. And he issued every single one unilaterally with no debate. I asked the question, are Hillary Clinton's emails really worth 1/3 of the committee's attention? Of course not. And what exactly is the emergency? As far as I can tell, the only emergency is the election approaching in a few weeks. I suppose the Republicans could argue that since Hillary Clinton's running for president, the American people should know everything they can before entering the voting booth. If so, I ask the simple question, then where is our investigation of Donald Trump? His potentially fraudulent business practices, his campaign's potential connections to Russian hackers. What about that emergency? His charitable foundation's illegal campaign donations, pay-to-play schemes, and payments to settle corporate debts. The answer is obvious. The Republican frenzy is focused exclusively and obsessively on Secretary Clinton, and that is for political reasons. I do believe that this is an abuse of authority and taxpayer dollars to inappropriately affect the presidential election. There's one key fact that everyone needs to understand about today's vote. Mr. Pagliano has already asserted his Fifth Amendment right before this very Congress on this very topic. In fact, he did it in person, right in front of me and Chairman Gowdy on the Benghazi Select Committee. This critical fact is not mentioned anywhere in this contempt resolution. Not mentioned. You can search all you want, but you will not find it. Why is that fact so crucial? Because it demonstrates that there is no legitimate legislative purpose in forcing Mr. Pagliano to assert his Fifth Amendment rights before Congress a second time. And there is certainly no legitimate purpose in forcing him to do so in public. To do so could open the floodgates for every Republican-led committee on Capitol Hill. Committee members may not know this, but last Friday, the chairman sent U.S. Marshals, yes, U.S. Marshals, into Mr. Pagliano's workplace to personally serve a second subpoena for his appearance before the committee. The committee could have sent a staffer in a coat and tie, but they sent federal marshals with guns. This served no purpose but to harass and intimidate Mr. Pagliano. The chairman ordered this action in secret, without even notifying the Democratic committee members of his plan. Got an emergency going on here. Secret. No consultation. Secret. No debate. Secret. No vote. Secret. Emergency. These actions are the definition of abuse. They are harassment. And I believe that they are unethical. I've said it before and I've said it again. And I echo the passion of Mr. Lynch, who has spoken on this subject extensively. The committee's actions in trying to force Mr. Pagliano to come back to Congress and invoke his Fifth Amendment rights yet again raise serious legal, ethical, and constitutional concerns. Members should not be placed in a position of voting for a resolution that could subject them or their staffs to potential disciplinary action. The American Bar Association, the D.C. Bar, and the Maryland Bar, which I have been a member of since 1976, all have ethics rules that prohibit attorneys from taking actions to embarrass, harass, or burden private citizens. It is professional misconduct. The D.C. Bar's Legal Ethics Committee warns that no attorney should compel any witness to appear in a congressional hearing when, and I quote, "it is known in advance that no information will be obtained and the sole effect of the summons will be to pillory the witness," end of quote. That is exactly what we have here. Now, Republicans may try to argue that Mr. Pagliano received immunity from the Justice Department, but that immunity agreement was limited, and we all had the opportunity to read it just this morning to confirm that. That is why a federal court has already ruled that Mr. Pagliano can continue to assert his constitutional privileges in separate proceedings, which he has done. As I close, what exposes the committee's abuses for what they really are is this. If the chairman really wanted to just obtain Mr. Pagliano's Fifth Amendment assertion for the record, he could have easily held a closed deposition, just as Chairman Gowdy did on the Benghazi committee. But that is obviously not the goal here, ladies and gentlemen. Republicans want a photo op. They want a ready-made campaign commercial. No matter what anyone says, that is not a legitimate legislative purpose, and as I've said before, I deem it and believe it to be unethical. Although I strongly support the committee's authority and prerogatives of the House of Representatives, I simply cannot vote for a resolution that is potentially so unethical that it could subject members of this committee or our staff to disciplinary action. For all of these reasons, I urge all the members to vote no on this resolution, and I yield back.
Gentleman yields back. I'd ask unanimous consent to enter into the record all the correspondence we've had with Mr. Pagliano's attorneys. Without objection, so ordered. To recognize the gentleman from South Carolina, Mr. Gowdy, 5 minutes.
Thank you, Mr. Chairman. I suspect most members of this committee know how they're going to vote. They probably knew earlier this morning how they're going to vote, so I don't think any of this is going to change any minds. But I do want to talk for a second to the folks who may be following this back home, just trying to figure out what these lawyers are arguing about. Mr. Chairman, there are two separate issues at play. Number one is whether or not you have to come when you have been issued a summons or a subpoena. There are people sitting in jury rooms right now all across this country because they received a summons. Even though they're not going to be called for jury service, they may be excused, they may frankly be disqualified. But you still have to come. There are subpoenas being issued all across this country to firefighters and EMS and police officers and doctors and everyone else who may have witnessed anything from a crime to a traffic accident. They may not get called as a witness, but they have to come. So issue number one is whether or not you have to come when you are issued legal process. And the answer is yes. The witness himself or herself does not get to pick and choose which legal process you're going to follow and which one you're not, or nobody would go to jury service. So issue number one is, do you have to come? Issue number two is whether or not you have to talk. And unless your name is Jack Bauer, you cannot force anyone to talk. Now, we can have a robust debate about whether or not this witness has been immunized. I read the immunity agreement. And what I find interesting is the doublespeak that I hear from some of my colleagues. You cannot, in one sentence, say DOJ has refused to prosecute, that this is a nothing case, and then the next sentence say you're worried that DOJ is going to prosecute. Congress cannot prosecute anyone for anything. Nothing. The only entity in this country that can level criminal charges is the executive branch. And they have already said they're not going to do so. So where is his criminal exposure? Where is it? Unless they're going to say, Mr. Chairman, that we are worried that he is going to make a false statement before Congress. Now, that would be interesting if that's the argument. We are worried that this witness who cooperated with the FBI may tell Congress something different. Well, guess what? The agreement he has with the Department of Justice requires him to be truthful. So you would want people to say the same thing to Congress that you say to the FBI. This is what I find most interesting of all. The Department of Justice has already said they're not going to prosecute anybody for anything. This matter is closed. Nobody's going to be prosecuted. But I'll bet you that agreement allows for this witness to cooperate with other entities of government. In fact, in the old days, it required that witness to cooperate with other entities of government. And I'll tell you why, Mr. Chairman. I have sat while some of the very members who are sitting in this room right now provided oversight over the FBI, over national security letters. They didn't give one whit second thought about second-guessing the FBI and the issuing of national security letters. I mean, who else would provide oversight over the FBI if not for Congress? And I listened to some of the very same members on this committee provide oversight over the Department of Justice, over the prosecution of Ted Stevens. So they have no problem providing oversight over the Department of Justice when they don't like the outcome. But when they do like the outcome, oh, no, 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 we cannot second guess. That is the one entity in this republic that can never be second guessed is the FBI. I find that fascinating, particularly coming from as many criminal defense attorneys as we have on the other side who made a dadgum living questioning the FBI. I mean, that's how they made their living, is second guessing the FBI. But no, once you take the oath of office for Congress, whatever they do, you don't want to prosecute the big banks, FBI, we're fine with that. You don't want to do anything about the people who committed fraud during the housing crisis, we're fine with that. God forbid we ask the FBI anything. All I want to know, Mr. Chairman, is did you give immunity to the person who destroyed federal records after a subpoena was in place? That's a fair question, and I would think every member of Congress would want to know the answer.
Does any other member wish to speak? We'll recognize the gentleman from Massachusetts, Mr. Lynch.
Thank you, Mr. Chairman. It is my opinion, at least from the course of these investigations, that Mr. Pagliano has indeed previously complied with a subpoena for the same information that the committee seeks today. And he has been given limited use immunity, only limited use immunity in the previous interviews, which would, again, expose him to possible prosecution if he were to, I think it's reasonably predictable that he would be subject to criminal prosecution because of the referral by this committee on this matter. In essence, what's going on here is this is really what we're engaging in is a review of the decision by Director Comey not to prosecute. That's what we're doing here. That's why the prosecutorial notes were requested by this committee and surrendered. That's why all of this is ongoing, because this committee wishes to go beyond the legislative function we have and to have a de novo review of what the Attorney General has dismissed and closed and what the Director of the FBI has refused to prosecute. I think that especially this is a violation of the separation of powers clause in the Constitution. I think what we're doing here today is something that is denied even to the judiciary. When a prosecutor looks at the facts, and this was an extensive interview process, a review process, investigation process, when they decide that there are not sufficient facts to prosecute, then that is their decision. They can decide which statutes to prosecute under and whether to prosecute. And that decision has been made. And because of the nearness of the election, this committee is going where no committee has gone before, to basically review the decision of the FBI not to prosecute in this matter. And this particular hearing to hold Mr. Pagliano in contempt really boils down to this, is that the chairman is saying that his rule is that the witness has to come before the committee and be subjected to what the witnesses were subjected to last week, which was total embarrassment. We had quotes of emails that were read and other evidence, and forcing them to repeatedly declare their Fifth Amendment rights, being publicly embarrassed on TV. That's the chairman's rule, but that is not the law. We know because in previous hearings, Mr. Gowdy, and I give him credit, in compliance with the law, brought that witness in a closed hearing, an executive session, and that witness exercised his Fifth Amendment rights. And that was the decent and fair and legal thing to do. That's not what we're doing here. We're continuing to try to embarrass this particular witness as Mr. Gambetta and other witnesses were embarrassed, Mr. Thornton, last week. And that is not necessary. And I think it's beneath the dignity of this committee and as well, I think, violative of the constitutional rights of that witness. That's what this boils down to. And I think this contempt proceeding will have short shrift in the district court. I don't think it's going anywhere, and I take comfort in that fact, because we are so far afield from the Constitution again in this committee. Not only the Fifth Amendment, but also now the separation of powers, where we try to take up anew this this matter that's been settled by the FBI director and the Attorney General.